Welcome. I'm Lucinda Lowe, the president of the American Society of International Law. Thank you. No applause. And it's my great pleasure to welcome you to the opening plenary of the 111th ASIL annual meeting. And welcome to our distinguished guests, Professor David Armitage, Professor Mary Dudziak, and Dean Nelson. Now, the Grotius Lecture has long been a highlight of the annual meeting, and we'd like first and foremost to acknowledge the continuous partnership of the American University's Washington College of Law for the past 19 years. And it's my pleasure to introduce to you the new dean of the American University Law School, Camille Nelson. Camille Nelson is a Canadian-Jamaican legal scholar and law professor who became the 18th dean of American University Washington College of Law in 2016. And in that capacity, she's the first woman of color. Prior to joining the school in July 2016, she served as the dean of Suffolk University's School of Law. She was the first Black woman to clerk for the Supreme Court of Canada. Born in Jamaica, Dean Nelson received her bachelor's degree with high distinction from the University of Toronto, her law degree from the University of Ottawa, magna cum laude, and her Master of Laws from Columbia Law School. She's a noted expert on the intersection of critical race theory and cultural studies, with a particular emphasis on criminal law and procedure, health law, and comparative law. So without further ado, let me invite Dean Nelson to the podium.
Greatly appreciate it. Thank you so much, Lucinda. Madam President, I greatly appreciate it. Good evening, everyone. Good evening. That's good. Thank you very much for your kind comments, Ms. Lowe, I appreciate it, and for your visionary leadership of the American Society of International Law. Thank you also for the transformative and critical role that you and your colleagues have played in upholding and advancing international law and justice. It is my great pleasure to welcome all of you to this 19th annual Grotius Lecture, an event that is the product of a creative partnership between the American Society of International Law and American University Washington College of Law's International Legal Studies program. The purpose of this event is to celebrate the life and legacy of Hugo Grotius, a founding father of international law, through presentations by leading voices, important leaders from varying disciplines and perspectives, all vital to our ongoing understanding and appreciation of international law. Now, today's Grotius lecturer, Dr. David Armitage, and our distinguished discussant, Dr. Mary Dudziak, follow a distinguished group of speakers who have commanded this podium, and all of whom have embodied and celebrated the commitment to the rule of law in international affairs. In today's tumultuous times, conflicts often take on new and dangerous forms, frequently featuring internal conflicts and sometimes transborder disputes with networks of militants beholden to no territorial state, at least as most of us were brought up to conceptualize same. These conflicts do not neatly fall within the prototype of state conflicts that were central to the foundational notions of international law as many of us came to know it. These types of conflicts, while not entirely new, of course, are with us. They persist and have been consistent from the time of Grotius. It is thus fitting that we turn to two historians today, those presenting their thoughts on civil wars, these lingering legacies of contemporary challenges that for some reason remain. In that spirit, please allow me to introduce today's two speakers, both leaders. Our Grotius lecturer is Dr. David Armitage. Dr. Armitage, he is the Lloyd Blankfein History Professor and former chair of the Department of History at Harvard University, where he teaches intellectual history, international history as well. He is also an affiliated professor in the Harvard Department of Government and an affiliated faculty member at Harvard Law School, an honorary fellow at St. Catherine's College, Cambridge, and an honorary professor of history at the University of Sydney. A prize-winning teacher and writer, he has authored and edited 16 books, among them an edited version of Hugo Grotius's The Free Sea and the Law of Nations in Global History by C.H. Andrewich. Hope I pronounced that sufficiently accurately. Co-edited as well is this anthology with the University of Chicago's Associate Professor Jennifer Pitts. In his most recent book entitled Civil Wars, A History of Ideas, Dr. Armitage not only takes us on a historical journey to discover the roots of civil war, but he also challenges our common perspective, arguing that despite its destructive nature, the experience of civil war has forced us to revisit our conceptions of democracy, revolution, humanitarianism, globalization, and international law more generally. In 2015, Dr. Armitage received Cambridge University's highest degree, the Doctor of Letters, for, quote, distinction by some original contribution to the advancement of science or of learning, end quote. Now, our distinguished discussant is Dr. Mary Dudziak, the Isa Griggs Chandler Professor of Law at Emory University School of Law. She is a leading U.S. legal historian and is president of the Society of Historians of American Foreign Relations. Her books include Wartime, An Idea, Its History and Consequences, Exporting American Dreams, Thurgood Marshall's African Journey, and Cold War Civil Rights, Race and the Image of American Democracy. In 2015, Dr. Dudziak was appointed by the Library of Congress as their Klug Chair in American Law and Government. She has also received fellowships from the John Simon Guggenheim Foundation, the American Council of Learned Societies, and has been a member of the School of Social Science Institute for Advanced Study at Princeton. Dr. Dudziak is currently working on a history of American war politics in the 20th century. And now it is my great honor to introduce Dr. Armitage to present this year's Grotius Lecture entitled Civil War Time, From Grotius Lecture to the Global War on Terror. Please join me in welcoming him to the podium.
I am deeply grateful to the American Society of International Law, especially President Lucinda Law and its Executive Director Mark Agrast, and to the International Legal Studies Program at American University Washington College of Law, in particular to the Dean of the College, Camille Nelson, and to Program Director David Hunter for their kind invitation to deliver this year's annual Grotius Lecture. Grateful, but more than a little intimidated. Nobel laureates and heads of state, eminent judges and leading diplomats have all stood at this podium, maybe not this very podium, but another podium for the Grotius Lecture, to give this distinguished lecture. But never before, I think, has there been a humble historian in this position. And I am truly humble at this point to be standing, as Isaac Newton might have said, on the shoulders of the giants who came before me. Now, as you're all aware, the theme of this year's meeting of the ASIL is what international law values. I'm going to be rather perverse this evening, I hope not also ungracious, in addressing a subject international law did not value, at least until quite recently. That subject is, of course, civil war. Just to take a couple of examples, I'll give you a quotation from the early 19th century. To want to give maxims for civil wars would be absurd. That was the early 19th century Swiss theorist of war, Antoine-Henri Jomini. Jomini explained that civil wars were more destructive and cruel than conventional wars because he thought they were ideological and therefore irrational, and for that reason beyond normative constraint. Attitudes like his prevented the extension of the original Geneva Convention of 1864 to civil wars. As one of the convention's drafters, Gustave Moynier, said dismissively, it goes without saying that international laws are not applicable to civil wars. As we'll see, it would take more than another 80 years before international law would take civil war seriously in the wake of the Second World War. Not for nothing, I think, did Michel Foucault once write of what he called the most disparaged of all wars, not Hobbes, not Clausewitz, not the class struggle, but civil war. Civil war, as you can tell from those brief quotations, has long been a Cinderella subject. There is no great treatise entitled On Civil War to stand alongside Clausewitz's On War or Hannah Arendt's On Revolution, for instance. And none of the great modern theorists of war, from Machiavelli to Mao, addressed civil war head on. Likewise, civil war barely registered in the classic law of nations. As we shall see, even Hugo Grotius himself was somewhat baffled and ambivalent on the topic. And it was only really in the 19th century that civil war became first an object of attention for lawyers, international lawyers and students of the laws of war among them. Even then, it still faced stiff resistance, and even what we might call repression from legal consciousness. Only really in the late 20th century did international lawyers come to value civil war. If by value we mean to pay civil war sustained attention, to expand their horizons to encompass civil war, and to accord law some normative force over the conduct of civil war. My story then, over the next 40 minutes or so, will be one of a subject that international law devalued and later re-evaluated in the 4 centuries since Hugo Grotius himself wrote in the early 17th century. I've tried to relate the history of civil war at greater length in the book which Camille kindly mentioned a moment ago, Civil Wars, A History in Ideas, which appeared early this year. This book treats debates over the meaning and the application of civil war from ancient Rome to the present, from Sulla to Syria, if you will, in a series of discourses including poetry, oratory, history, the social sciences, and, of course, law, from Roman law up to contemporary international humanitarian law. Now, to give more focus to what could be a much longer and more winding analytical argument drawn from that book, this evening I concentrate on what I've called civil war time. I think many of you in this room will recognize in my title an allusion to one of the pivotal books that have inspired an ongoing dialogue between international lawyers on the one hand and international historians on the other. That is, of course, Mary Dudziak's Wartime, an Idea, Its History and Its Consequences, published from Oxford University Press in 2012. My argument about civil war time, about the expansiveness, the elasticity, and the seeming interminability of civil war owes a great deal to the inspiration afforded by Mary's work on law and temporality. And it's therefore a very special honor for me, as well as a great pleasure, that Mary generously agreed at quite short notice to be the distinguished discussant for this Grotius lecture. My thanks go to her in advance for her comments and, of course, for her criticisms as well. Now, as Mary reminded us in that book and associated writings, the standard view of the relationship between war and time can be deceptively straightforward. And here I'll ventriloquize her ventriloquizing of this broader understanding. There's a normal condition that we call peace, or the absence of war. A war is declared, marking the start of that exceptional condition we call wartime, that, quotes, tract of time wherein the will to contend by battle is sufficiently known, as Thomas Hobbes famously put it in his Leviathan of 1651, and then Hobbes went on equally famously to say, all other time, that is the time when that will to contend by battle is not sufficiently known, is peace. Because war is directed towards some end, to victory, to a treaty, to the resumption of peace, we generally assume that it will be finite, that war will come to an end. And Mary has put this common understanding much more crisply than I could. And here I'll quote her. We tend to believe that there are 2 kinds of time, wartime and peacetime, and that history consists in moving from one kind of time to the next. Built into the very essence of our idea of wartime, she goes on, is the assumption that war is temporary. The beginning of war is the opening of an era that will, by definition, come to an end. Now, she dedicates her whole book to unpicking, indeed undermining, that illusion by showing just how difficult it has been to determine when wars, especially the US's modern wars like the Second World War, the Cold War, and the War on Terror, actually did end, or in the case of the global war on terror, whether it ever would end or indeed could end. When wartime ceases to be bounded, it opens up the prospect of endless war, a forever war, as some have recently called it, with no sign of victory, no hope of peace, and potentially no end to wartime, as the state of exception becomes entirely unexceptional. As Hobbes might have said, under such conditions, the time of peace vanishes, and a known disposition to fight never seems to go away. In the rest of this lecture, I'll leap off from these observations to argue that civil war, that is, large-scale armed conflict among the members of a single political community, is even more slippery, and that it has still more disturbing temporal implications even than international or interstate armed conflict. There may be three reasons for the peculiar challenges civil war presents in this regard. First, as I'll show, it's rarely been clear when a civil war begins. Second, it's been equally uncertain just when civil wars end. And third, because civil wars so often recur, the idea that they begin or end can be quite contentious, even dangerously fallacious. Now, far from being an outlier or an anomaly, as almost all theorists of war and of law have deemed it to be, civil war, I think, will emerge as exemplary of how to think about the relations among law, war, and time. Because civil wars are never formally declared, they have uncertain beginnings. Even when they are formally concluded by surrender, armistice, treaty, or simply by crushing military victory, for instance, they resonate in historical memory and keep conflict alive, even after the swords have been sheathed or the guns have fallen silent. How international law treated civil war, I think, can be a particularly revealing index of these conditions about civil war and its relation to war and wartime more generally. It's also an index, as I hope to suggest, of what international law has valued in the past and what it may now value in the present, especially when beginnings and endings, civil peace and civil wartime, have been at stake. For ours is now, we might say, a world of civil war. After 1989, civil war gradually became the most widespread, the most destructive, and we might also say the most characteristic form of organized human violence. If the 300 years between 1648 and 1945 comprised an era of interstate war, then we might say the last 60 years have been an age of intrastate conflict, of civil war. Indeed, the most striking change in patterns of conflict in that period has been precisely that shift from war between states to war within them. Since the end of the Cold War, an average of 20 intrastate wars has been in progress at any one time. That is about 10 times the annual average for the decades between 1816 and 1989. The global estimate of battle deaths in these wars since 1945 is over 25 million people. That is about half the estimated direct casualties in the Second World War. But even that count doesn't include the civilians, the wounded, or those who die from the knock-on effects of civil war, such as disease, malnutrition, and displacement. As we now know very clearly, civil war is no respecter of borders. It turns countries inside out. Think not just of the almost 500,000 Syrians who perished in their civil war since 2011, but also more than half of that country's population civil war has uprooted, both internally and externally. In the 21st century, we can say that almost all wars are now civil wars. In 2015, the last year for which we have complete figures, there was only one conflict we can call an interstate conflict, that between India and Pakistan over Kashmir, which in that year had fewer than 30 casualties. All of the other 50 or so conflicts around the globe in 2015, from Afghanistan to Yemen, were internal conflicts of varied kinds. However, these civil wars in the 21st century do not usually stay civil, if by that we mean internal to a set of political borders, for very long. 1/3 of the world's supposedly internal conflicts have become internationalized civil wars, that is, conflicts that draw in forces from neighboring countries or intervention from outside powers. Now, amid the horror of contemporary civil wars, I think temporality is one of the sources of that horror. We now know that wars within states tend to last longer, some 4 times longer than wars between states. And that problem has only grown worse in recent years. In the second half of the 20th century, civil wars generally lasted 3 times longer than they had in the first half of the 20th century. We also know that these conflicts are much more prone to recur than any other forms of armed conflict. Indeed, as one leading scholar of the subject has noted, the most likely legacy of a civil war is a further civil war. And almost every civil war in the last decade was, in fact, the resumption of an earlier conflict. The interminability of civil wars, the wounds they leave, the memories they scar, the specter of recurrence that they raise, is one of their most noted features across history. I question whether any serious civil war ever does end, the poet T.S. Eliot said in 1947. All wars are bad, agreed former French President Charles de Gaulle on a trip to Spain in 1970, because they symbolize the breakdown of politics itself. But civil wars, in which there are brothers in both trenches, are unforgivable because peace is not born when the war concludes. The consequence, indeed, is often what one Spanish historian has more recently called a long, uncivil peace after civil war. Now, these features of civil war, their interminability, the impossibility of bringing them to an end, the scarred memories, and the fear of recurrence are nothing new. The recursive, never-ending nature of civil wars was familiar as far back as the Romans, who knew that civil wars came not singly, but in battalions. They left wounds that would not heal, heirs who demanded vengeance, divisions that would split first the city of Rome and then the entire Roman Empire of the Mediterranean and beyond. They were battles without victories, the Romans wrote, and they brought only defeat. As such, they were also wars which could bring no triumphs, struggles that could not end with the usual ceremonies for concluding formal conflict. Among the repeated legacies of the Roman heritage were 2 lessons about civil wartime that would resonate down the centuries. The first, that it was rarely clear when civil wars had actually begun, and second, that it was abundantly clear that they might never end. Now, baffled as they were by the recurrence of their own civil wars, the Romans tried to work out just when and why those wars had indeed originated, and they dug back ever deeper into the ethical history of their own commonwealth, even as far back, for instance, as the primal fratricide of Romulus and Remus, in search of what the Roman historian Tacitus called the trial runs for civil war, the indications of where these came from so they could be avoided in the future. The Romans found so many origins for their civil wars, so many beginnings, as well as so many instances of those wars, that they likened them to natural phenomena like volcanoes that would fall dormant only to explode again without warning. In the terms later laid down by Thomas Hobbes, for well over a century, Rome found itself in the midst of civil war time, in which the will to contend by battle was sufficiently known to be repeatedly feared, and when peace would be no more than a vain hope or illusion for almost 3 centuries of Roman history. At least until the 19th century, and the great historical watershed marked by the American Civil War, civil wars were seen through Rome-tinted spectacles as cumulative historical phenomena. Their sequential recurrence gave shape to the past, but also projected the likelihood of endless internal conflict in the future. European inheritors of Rome's traditions saw their own internal troubles as the culmination, or perhaps even the repetition, of that cycle of similar wars that had been unfolding in Roman history and that later played out across Europe in the centuries after the fall of the Roman Empire. So England alone had been through the Barons' Wars of the 13th century, the Wars of the Roses in the 15th, and then the Civil Wars of the mid-17th century. Italy had civil wars in the 15th century, followed by the French Wars of Religion, and at the end of the 16th century by the Dutch revolt against the Spanish monarchy. about which Hugo Grotius himself wrote a history in which he called that conflict the Dutch Revolt, something that wanteth not reason why it may not be termed a civil war in the Netherlands of the time. Now, Grotius was the first theorist of the law of nature and the law of nations, that early modern discourse that preceded what came later to be called international law, to grapple with the meaning of civil war. He defined war generally as, quotes, armed execution against an armed adversary. And throughout his major works, he wrestled with the question of what kinds of such war could be just. In his very earliest reflections on the subject in 1604, he distinguished between what he called public wars and private wars. Public wars being executed by the public will or the legitimate sovereign authority in a state, private wars being waged by others than that public will, other forces than that. Only once he had established that fundamental distinction between public and private wars did he go on to describe civil war as that kind of public war which is, he said, waged against a part of the same state. And this is about as much as he said on the subject in 1604. When he returned to the question 20 years later, in his masterpiece, The Rights of War and Peace in 1625, he added a new category that he called mixed war to his typology. That is a war fought on one side by the legitimate authority, on the other by those he called mere private persons. Yet he still firmly opposed private war, even against a usurper, at the cost of engaging what he called a country in dangerous troubles and bloody wars, and quoted Roman sources in support of his position that civil war of this kind must be avoided at all costs. And as he wrote there, a civil war is worse than the necessity of submitting to an unlawful government. Any peace, he said, is preferable to a civil war. So civil war for him could never be encompassed under the meaning of just war. Conservative arguments like this, in which Grotius preferred even tyranny to civil war, even the peace of a tyranny, earned him the contempt of later thinkers like Jean-Jacques Rousseau, who saw him as little more than a defender of tyranny and slavery. Sorry to remind everyone of that when we're supposed to be celebrating Hugo Grotius, but I feel it's important as a historian to remind you of the multifaceted nature of his character and the way in which he's been perceived through time. It can also, I'm afraid to say, hardly be said that Grotius took civil war very seriously, or that he tried to explain it rigorously within the context of his broader conceptions of war, peace, and justice. In his reluctance to value civil war, he was typical of more than a century of reflection within the later tradition of the law of nations. Indeed, it wouldn't be till the middle of the 18th century that any thinker within the tradition of the law of nations would rigorously analyze civil war. And it's here, where I'll turn now in the 1750s, that we find a genuine pivotal moment in considerations of civil war and of the transformations that take place from domestic peacetime to civil wartime around questions of war and peace, criminality and belligerency. And I'll turn now to the work of the now mostly forgotten Swiss jurist Emma de Vattel. I always say mostly forgotten to other historians, but I think in this room at least, I can be assured of people recognizing his name, and I'll just run over what I think is his genuinely crucial contribution to the reconceptualization of civil war to bring it under the law of nations. Vattel, like his predecessors, including Grotius, to whom he acknowledged his debts, drew lines among different species of war in his Droit des gens of 1756. He disagreed with Grotius that there could be any such thing as a private war, and like, for example, Jean-Jacques Rousseau, he defined war precisely and exclusively as a conflict fought between two states or nations alone. It was, in his words, quotes, public war which takes place between nations or sovereigns and which is carried on in the name of the public power and by its order. Now, facially, that might seem to be a definition which would exclude civil war from the laws of war and from the determinations of justice or injustice in war. But I'll show now how Vattel reconceptualized civil war to bring it under that definition. His crucial innovation was to argue that those rebels against a sovereign or public power could legitimately be recognized as belligerents rather than simply as domestic rebels. With that move, he opened the way both to the application of the laws of war to civil conflicts and to a radically new conception of civil war and of civil war time. He argued, along with John Locke, that, quotes, every citizen should patiently endure evils which are not insupportable unless they are denied justice, in which case resistance might be justified if, quotes, the evils be intolerable and the oppression great and manifest, an almost word-for-word translation of lines from Locke's second treatise, which of course you'll also recognize as having made their way into the US Declaration of Independence. Vattel may have been a Swiss jurist, but at heart he was also an English Whig of the late 17th century. But what, Vattel went on to ask, what if the sovereign's demands became intolerable and their own people had to rise up in arms against them? Then, he stated in a groundbreaking definition, we have a case of civil war. When a party is formed in a state who no longer obey the sovereign and are possessed of sufficient strength to oppose him, or when in a republic the nation is divided into two opposite factions and both sides take up arms, this, he said, is called civil war. It could be distinguished from a rebellion, for instance, by the fact that the insurgents had justice on their side. If their cause of opposition were just, then the sovereign, or the divided authority within a republic, must wage war against their opposition. Custom appropriates the term of civil war, he wrote, to every war between the members of one and the same political society. Vattel's conception of civil war and of civil war time marked what we might think of as an ontological shift that took place when the relations between ruler and ruled were transformed into tyranny and oppression, and therefore also on the other side, legitimate resistance and a case of just war. Now, the precise moment of the passage from one state to another might be impossible to pinpoint definitively. He admitted that. Certainly, it would not be revealed by any formal declaration of hostilities from one side or the other, as in an interstate conflict. The presence of civil war might therefore be recognizable only in retrospect. Vattel knew, as did others in the tradition in which he wrote, that there was no clear threshold, no signal or symbol that heralded the beginning of civil war time, whether with a formal declaration or a manifesto, as in contemporary interstate conflict. Nonetheless, he continued, the sides in a civil war may recognize each other as parts of the same political society. At the point they have splintered nonetheless into separate and hostile factions, as, quotes, that division produces in the nation what he called two independent parties who consider each other as enemies and acknowledge no common judge, and who therefore, and here's his crucial move, therefore become, quotes, two separate bodies and two distinct societies. By that moment of division, the unitary nation or state had ceased to exist, and the conflict had become a public war between two nations. It therefore no longer fell under internal domestic law. Civil war time had begun, even if the precise moment of transition remained elusive. Now, the importance of running through this argument is that Vattel would set the terms of debate on civil war in Europe and in the Americas, and therefore on civil war time, for at least a century after the publication of his work. His book, The Droit des Gens, The Law of Nations, would be an invaluable vade-mecum during later revolutionary moments, from the meetings of the Continental Congress to draft the US Declaration of Independence in 1776. It's the single identifiable book that we know was on the desk of the drafters of the Declaration in that year, through to the Latin American and Greek independence movements of the early 19th century. However, I'll skip over those moments to move now to perhaps the most important debate over civil war and civil war time before the late 20th century. That is, during the conflict we now know as the US Civil War of 1861 to 65, though I'll come back to that end date in a moment, a conflict in which Vattel played a remarkable posthumous role. Now, as I'm sure everyone in this room knows, today is the 156th anniversary to the day of the bombardment of Fort Sumter in South Carolina on April 12, 1861. Within a few weeks of that day, all parties, Northern and Southern, American and foreign, recognized the existence of a war within the borders of the United States. However, the question of just what kind of conflict this was, and hence what rules should apply to its conduct, remained controversial. In the eyes of supporters of the Confederacy, President Lincoln had prejudged the issue when he'd ordered ports from Chesapeake Bay to the mouth of the Rio Grande to be blockaded on the grounds that the states of the Confederacy had, as it was put at the time, raised an insurrection against the government of the United States. This meant, among other things, that Union forces could capture neutral shipping attempting to supply the Confederate States on the grounds that they were illegally supplying an enemy in time of war. Now we fast forward, of course, to early 1863, when the Supreme Court heard the 4 cases known collectively as the prize cases, which had been appealed from courts in Boston, New York, and Key West to question that decision in early 1861. As many of you will be aware, the plaintiffs had argued that the blockade and the subsequent use of prize law to distribute the proceeds from 4 captured ships applied the laws of war to a situation in which no war had been declared, and hence no such laws could operate. The main question before the court was therefore whether there was indeed a state of war which would justify the president's deployment of the laws of war at that point. Justice Robert Grier, writing for the majority in March 1863, was persuaded by the government's lawyers that there was indeed a war in progress. The absence of a declaration of war, he argued, prevented the government from treating its adversaries as belligerents. And here he wrote, "A civil war always begins by insurrection against the lawful authority of the government. However," he went on crucially, "a civil war is never solemnly declared. It becomes such by its accidents, the number, the power, and the organization of the persons who originate it and carry it on." The president was therefore bound to face that conflict, here again I quote Grier, in the shape it presented itself, without waiting for Congress to baptize it with a name. And at this moment, he gave one of the clearest statements up to that point of the sheer difficulty, indeed the near impossibility, of stating when any civil war, let alone the Civil War, had been initiated when it could not be solemnly declared. Now, behind Grier's judgment lay, as you may already have guessed, Vattel's epoch-making definition of civil war. Vattel himself had offered a factual account in the Law of Nations of when civil war broke out, and when all sides could recognize that 2 warring nations had emerged within the same territory. The existence of a war, Vattel thought, would be clear to all, and Grier followed him in that, by the number, the power, and organization of those who prosecuted it. The applicable war rules were therefore the Law of Nations, including the laws of war. The question in 1861 and later had been whether a rebellion or a civil war was taking place within the boundaries of the United States, and when exactly, if at all, there had been a shift from one state, rebellion, to the other, for instance, from domestic jurisdiction in peacetime to the sphere of the Law of Nations and the laws of war in Civil War time. Now, this collision of perspectives was a problem not only for politicians, but of course even more acutely for military commanders, especially those on the Union side. Under what rules of engagement would the Union Army treat the rebels? Did the laws of war apply, and would bringing them to bear imply that the conflict was indeed one between the forces of separate states? And why might it matter if this was not an international war, but in fact a civil war? Another of President Lincoln's advisors, the Maryland anti-secessionist and pamphleteer Anna Ella Carroll, answered such questions defiantly, also with support from Vattel. This, she wrote firmly, is a civil war, and therefore the government may employ all the constitutional powers at its command for the subjugation of the insurrectionary forces in the field. But while it's enabled to employ all the powers, it is obliged to observe at the same time all the established usages of war. For the same enlightened maxims of prudence and humanity are as obviously applicable to a civil war as any other. And in this, as we've seen from those earlier quotations I gave you at the beginning, she was something of an outlier, but a forward-looking one. And indeed, it was on the basis of that understanding that the first codification of the laws of land war was undertaken during the conflict by the Prussian-American lawyer Francis Lieber. At the heart of Lieber's thought during the 1860s was a deep ambivalence about whether or not to think of civil war as war at all. He believed that a civil war could have the features of both what he called a true war and a domestic police action against insurrection at the same time, but he also argued that not every insurgent could be punished as if they were regular criminals. It is a question of expediency, he said in some lectures at Columbia University in 1861, and not of law or morality. How to overcome the double nature of civil war, both as war and as rebellion, presented a dilemma Lieber could not quite resolve. And this uncertainty would bedevil his later attempts to define the boundaries between civil war and rebellion in the General Orders No. 100, of course better known by his own name as the Lieber Code. When in 1863 Lieber came to define civil war and rebellion in the body of his code, he still could not adequately distinguish between the two forms of internal violence. Civil war, he wrote, is war between two or more portions of a country or state, each contending for mastery of the whole and each claiming to be the legitimate government. The term is sometimes, he went on, applied to war of rebellion, when the rebellious provinces or portions of the state are contiguous to those containing the seat of government. Rebellion, however, he went on, was applied to an insurrection of large extent and is usually a war between the legitimate government of a country and portions or provinces of the same who seek to throw off their allegiance to it and set up a government of their own. Now, as you'll have spotted from those two definitions of civil war versus rebellion, according to the terms of those definitions, what was happening in 1863 was, in fact, a rebellion, not a civil war, according to Lieber's own definitions. This, of course, accorded with the very wording of the Constitution itself, which had provided for the means to, quote, suppress insurrections and permitted the suspension of habeas corpus, quotes, in cases of rebellion, as Lincoln, of course, had done with Lieber's advice and support in 1861. Abraham Lincoln himself referred to the conflict as a rebellion 6 times more often in his writings and speeches than he called it a civil war, making a mockery, we might think, of Lieber's anxious efforts at precision in distinguishing civil war from rebellion and insurrection. Now, whether rebellion or civil war, if we go to the end of the conflict or the supposed end of the conflict, it did not come to a clean end with the surrender at Appomattox on Palm Sunday, April 9th, 1865. By some historical accounts, the war was not concluded until 1870, as Republicans declared that wartime continued at least through Reconstruction. And we might even say that the ongoing contentions over the Confederate battle flag suggest that the embers of civil war time may not yet have cooled. As the Vietnamese author Viet Thanh Nguyen has recently written, all wars are fought twice, the first time on the battlefield, the second time in memory. That is especially true, I think, of civil wars. Now, one legacy of the US Civil War, the Lieber Code itself, proved to be germinal for the later Hague and Geneva Conventions. However, at its inception in 1863, it represented something of an outlier, as both international lawyers and students of war had adamantly continued to devalue civil war throughout the 19th century. They would not re-evaluate it until the aftermath of the Second World War, with the revision of the Geneva Conventions starting in 1949. The most pressing issue on the minds of many delegates at the diplomatic conferences of that year in Geneva was precisely how to extend the protections guaranteed to recognize combatants in conventional interstate war to the victims of conflicts not of an international character. The result of their deliberations, of course, was Common Article 3, which finally applied to what was then precisely termed unarmed conflict, not of an international character. Yet it would not be till 1977 that Additional Protocol 2 to the Geneva Conventions expanded the range of protections and prohibitions relevant to civil wars that remains in force today as the major component of international humanitarian law relevant to such struggles. The application of those protections depends, in large part, on the judgment that a conflict not of an international character is indeed in progress. So again, we return to that question of when a conflict begins and what its boundaries in time and therefore in law also will be. If the violence has not been deemed an international or a non-international conflict, because, for example, it's a riot or an insurgency in the eyes of the international community, it remains within the scope of the domestic jurisdiction of the state concerned, and hence subject to domestic police action. In such cases, a great deal can therefore hang on the determination of whether or not a conflict is not of an international character, whether or not, that is, a community has entered civil war time. Now, to see briefly why such a determination of the passage from insurgency or rebellion to civil war might matter, we can recall the case of Syria in 2011 to 2012. Ordinary Syrians seem to know very well throughout 2011 and the first half of 2012 that what they were experiencing, what they were suffering indeed amid contention with the regime of Bashar al-Assad, was civil war. Outside Syria, interested parties across the globe debated whether or not Syria had indeed already descended into civil war. The Syrian regime, of course, saw, as it still does, only rebellion. The opposition said they were engaged in resistance. and outside powers jostled with each other over intervention and non-intervention, and the determination of civil war or its absence had important implications for that, as it still does. More precisely, it took the International Committee of the Red Cross until July 2012, more than a year into the conflict, and after probably as many as 17,000 people may already have died, to confirm that what was taking place in Syria was, in fact, an armed conflict not of an international character. Only once that determination had been made did it become possible for the relevant parties to be covered by the specific necessary provisions of the Geneva Conventions. The reluctance to call a conflict a civil war or a non-international armed conflict has indeed become typical of international organizations in the 21st century, because so much politically, militarily, legally, we might even say ethically, now hangs on the use or withholding of the term. A set of legal protocols designed to humanize the conduct of civil war, to bring to bear humanitarian constraints on its practice, to minimize some of the terrible human cost of civil conflict, may sometimes serve only to constrain international actors in their attitudes towards those conflicts, such as the one in Syria. Expanding regulation of non-international armed conflict by international humanitarian law has had the perverse effect of making it harder for international organizations to apply that body of law under some circumstances, even as rebels and insurgents on the other side have increasingly tried to conform their combat to IHL's constraints. Indeed, in the decades since the Second World War, interstate wars have vanished almost to invisibility, in part because of the reluctance of states to call their wars wars and to give them definite beginnings and endings with the traditional ceremonies of declaring war, including peace treaties. The US, of course, has famously not declared any wars since the Second World War, and peace treaties in interstate war have declined almost again to invisibility in the 21st century. One reason, therefore, for the elasticity of international conflict is precisely this lack of identifiable markers for its inception and conclusion, and indeed Mary has mapped this very well in her book. Non-international armed conflicts are just as indefinite in their origins, but one paradox of the increasing penetration of international humanitarian law into those conflicts has been a marked increase in the number of them that have been terminated by treaties. So as one scholar has recently shown in recent years, more than 40% of civil wars have been concluded with a treaty, compared to none in the immediate aftermath of the Second World War. So the pattern of treaty conclusion in interstate war has been declining to nothingness, whereas it's been increasing now to 40% of all internal conflicts. Counterintuitively, then, civil war time is becoming more clearly defined, at least in the ending of conflicts, like, say, the Colombian Civil War, even as interstate warfare has become more expansive and open-ended in both directions. Yet even as civil war has in this way come into sharper relief, at least in regards to its termination, so its metaphorical reach has expanded, especially in the context of the global war on terror. In some circles, that conflict and the terrorism underlying it has been cast as a global civil war, an unbridled struggle between opposed parties without constraint, cast onto a global screen and pursued as a war of all against all, in which the boundaries between internal and external, interstate and intrastate conflict have become utterly blurred. This, we might say, is civil wartime run amok, a worldwide state of exception with no end in sight. Or in the words of the Italian theorist Giorgio Agamben, global civil war tends increasingly to appear as the dominant paradigm in contemporary politics, including and infecting, we might say, everything from international terrorism to the conduct of internal politics itself. In such a condition, civil war time, that tract of time, as Thomas Hobbes might have said, wherein the will to contend by battle is sufficiently known, even if it's not activated, can never be readily identified. There is often a battle of words before there is a struggle with swords, we might say. As Hobbes himself noted in his late 17th century history of the English civil wars of the period before the king called up his army in 1642, hitherto, Hobbes wrote, though it were a war before, yet there was no bloodshed. They shot at one another with nothing but paper. There may now be no more definite endings. There may be more definite endings for civil war, but there is still no formal sign for the passage from civil peace to civil war. As Justice Greer remarked, a civil war is never solemnly declared. It becomes such by its accidents. The boundaries of civil war remain, as ever, blurred and confusing. Past actors could only see in retrospect just when the war before might have been said to have begun, when divisions had opened, the sides had formed, and the contentions that would lead to open violence had their beginnings. With this in mind, we perhaps should be more vigilant about the deepening partisanship in our own politics, the seemingly unbridgeable gap of civility and comprehension between opposing sides, and also about the violent language used by some of our own politicians today. We might also pay more attention to the metaphorical language of civil war that seems increasingly prevalent to describe political differences within and between political parties in the United States as across Europe and Latin America. And one only has to open the newspapers or see headlines online to see that there's been a war within the GOP over over healthcare, that President Trump has waded into a civil war within the GOP, that the Vatican is currently having a civil war, that the Tory and Labour parties have civil wars of different kinds. Macron in the French presidential elections said just this morning that the French right was trying to foment civil war in the context of the French elections, and so it goes on and on and on. This is very unsystematic evidence, of course, but I think the ramping up of the language of civil war across the world at the moment shows that in some sense across the world, democratic politics is becoming civil war by other means. With this in mind, we might worry, indeed be very concerned, that we're entering civil war time without our knowing it. Ours is therefore, I think, a particularly urgent moment to focus, as this conference does, on just what and also upon whom, also who we value, what we share in common, who we join with in conversation, what goals we set, and what binds us together, despite our principal disagreements. A particularly urgent moment to focus on what we value, both nationally and internationally. Thank you so very much.
Thank you very much, Dr. Armitage, for your very thought-provoking presentation. We are all the wiser for you having taken the time to share your thoughts with us. We appreciate it. It is now my great pleasure to invite to the podium our distinguished discussant, Dr. Mary Dudziak of Emory University Law School. She will share her thoughts on Dr. Armitage's lecture. Welcome, Dr. Dudziak. Thank you. No, of course. Let me know if you want any water. Oh, yes. Actually, I'm good. Okay. Yeah, thanks.
It is such a pleasure and an honor to be with you here today. I have to say, I can't see you at all. They're just bright lights shining in my face. So, but I'm just so happy to be here, and what a pleasure to have an opportunity to comment on a lecture by David Armitage, an intellectual historian of unparalleled reach and impact. And I strongly recommend to you his elegant, characteristically elegant and brilliant new book, Civil Wars. Thank you also to Dean Nelson, to President Lucinda Lowe, and to Mark Agrast for all that you've done to bring us together. Now, I will end up focusing more on what we might learn from the American Civil War experience and how that might help us think about temporal issues or their problems in the context of thinking about contemporary peacetime. Historians interrogate the past, but the present is unescapable. We can see this powerfully in David Armitage's Civil Wars. The stakes are now so high for applying or withholding the label of civil war, he writes. Our ideas of civil war transmit the pain of 2,000 years. That pain enters contemporary politics, he suggests. In that way, a historic category is more than an artifact. It continues to shape the way we understand our world and the choices that we believe are available to us. Is there water?
Yeah,
oh,
sorry, I just didn't know where to put it up.
So one of the things he does in the book is sort of to break war into categories in a way that's very useful and helpful. And I want to think about the category of civil war and its relation to social and political life. And to think about what I think of as civil war's civilness, and to see what the concept of civil war in the American past enables us to see and perhaps not to see. Professor Armitage mentions categories other than civil war, but principally civil war and its essential opposite are the subject of his work, and the opposite is interstate wars. The Civil War is interesting as a matter of intellectual history because it was an aberration from what was the normal kind of war, interstate wars. Recognizing civil wars then enables him to examine violence in the world during the post-1945 years, an era that some have called the Long Peace. Now, if civil war was a new operative category of legitimized war, what does that category leave out, and what are the consequences? To think about this, I'd like to take you back to 1864, when there were two simultaneous conflicts, both involving U.S. armed forces, the Civil War, and what we call the Indian Wars. So first turning to the Civil War, it's very interesting in American historiography, and it's sort of, David's book puts it in sharp relief. In the history of American wars, the Civil War is treated as legitimate, not just because civil wars fit in the category of real war. In American legal historiography, it has instead become, in essence, the ideal type of American war, with essentially its sort of deviation from interstate wars forgotten or not sort of interrogated. In scholarship examining American war powers, the Civil War is not treated as different from interstate wars, at least not much of the time, but instead is treated as the most important example of how American war powers operate in any context that we call a war. It has received more ink in the war powers literature than the Cold War, for example, in spite of the fact that the Cold War was the occasion for the development of the modern national security state, a governmental framework that continues to structure the U.S. government's war and security work. But structural differences between a war within a polity and an international war are sometimes sort of obscured. The history of the Civil War, the American Civil War, can help us think about, again, what's the civilness in civil war? The principal character of the war's civilness, at least the American Civil War, as it's been thought about, was its constitutive character. The Civil War constituted a public through its destruction. That idea is at the heart of an especially important work on the American Civil War, Drew Gilpin Faust's book, This Republic of Suffering, Death and the American Civil War. Enduring divisions survived the war, of course, but Faust argues that war's carnage also enabled enduring ties and essentially produced a broader public. This is captured in the idea of a republic of suffering. There were over 600,000 military deaths, so that the human carnage required state and society to respond to it. Names had to be attached to the bodies, then recorded and remembered. Entire bureaucracies were needed to simply account for the dead. Families searched battlefields for remains, disinterring bones of others along the way. Faust's concept of a republic constituted through war death is perhaps best illustrated by the source of her title, a quote from Frederick Law Olmsted, most well known for his path-breaking landscape architecture. Now, Olmsted was still in the process of trying to find a satisfying career when the Civil War broke out and he found work on a hospital transport ship. Olmsted reflected on the community that he found among the injured and dying soldiers. They called out to each other. They supported each other, telling a nurse, for example, "Go help Johnny over there. He needs you more than I do." The Civil War's civilness was on display on Olmsted's ship. It was humanizing, though all around there were broken bones, open wounds, the dead and the dying. Suffering, in his perspective, produced a community, and writ large, Civil War death was central to constituting a polity. The dead do cultural work for the living, Thomas Laqueur argues in an important new work. If the dead do cultural work, then they must also do political work. The political work of the dead and their role in constituting a polity were on display when Lincoln commemorated Civil War dead at Gettysburg, essentially saying it was the living who were there to be commemorated, to carry out the work for which soldiers had given their lives. As Professor Armitage shows, the Lieber Code's definitions of civil war and rebellion turned on the relationship of violence to a civil object, the division of a polity, and the creation of a new state or the assumption of power over an existing one. But all forms of political community were not protected by the code. It was a code of civilized men, and its rule was in service of civilization. Every polity has an outside. We can better understand the nature of the Civil War's civilness by examining the outside of the Civil War polity. There was death and suffering at the hands of American military forces in the 1860s that fell outside of Faust's Republic of Suffering. It helped to constitute the Republic nevertheless by showing its outside, the border of civilization between the deaths widely mourned and the others forgotten. Political scientist Helen Kinsella shows the impact of a border of civilization in her brilliant book, The Image Before the Weapon, on the history of non-combatant immunity. This issue is illustrated by a rather brutal story from armed conflict in Colorado in 1864. Norms were shifting regarding the protection or the need for elimination of peaceful communities of Native Americans. Colorado Governor John Evans first told the Cheyenne and Arapaho that if they were loyal and peaceful and they registered with his government, they would not be attacked, but would be protected. A Cheyenne village at Sand Creek took him up on his offer. But 2 months later, Governor Evans changed his mind. How, after all, could one tell between loyal and disloyal Indians? As human beings, they were of a different character than the white Northerners and Southerners fighting the Civil War. They were the kind of barbarians that, thanks to the Lieber Code, the Union Army could distinguish itself from in honorable conduct. But the Code's limits did not apply to conflict with people thought of as savages. The Indian Wars were not treated like the Civil War battles between peoples for sovereignty, although that's what in part they were. They were battles on behalf of civilization against the savage threat. This was the kind of logic behind leaving the Lieber Code aside for the Indian Wars. Quote, protection was and still is with uncivilized people the exception, Lieber himself wrote in 1863. Before American troops descended on that peaceful village at Sand Creek, Colonel John Shivington told his men to kill and scalp all, little and big, for nits make lice. The result was an orgy of violence. Women were not spared, but were raped and cut into pieces. Babies were shot at point-blank range. The Cheyenne at Sand Creek were forcibly eliminated from the face of the earth in the name of upholding civilization. There was, of course, no Gettysburg Address delivered at Sand Creek. This was not only because the casualties were Native Americans. It was that the sacrifice was not shared through mourning that transcended political boundaries. The entire point was an exclusion from the polity. After all, Sand Creek is remembered and mourned by Native Americans. It remains at the boundary of American memory. Unlike the Civil War's constituted character, the Indian Wars are more often constitute American political identity through their exclusion. The point of this story is not to show that the code of war the Civil War produced did not end atrocity, for of course it could not do that. Instead, the story shows the borders of the civic community and civil society that the Civil War's fighters and commanders thought the war was about. A republic was constituted out of the war's carnage, as Faust argues, but the republic had an outside, a border between the deaths to be mourned and those to be forgotten. This brings a ragged edge to the civilness of the American Civil War, and it sheds an important light on the character of what kind of peace we might find in its aftermath. If, drawing from Faust and Lecoeur, death in war has a politics, if the polity has been shaped in relation to the shared experience of suffering and death, what happens to a polity when war is far away and a warring people do not themselves suffer? I'm, of course, talking about us. Can Kant's peace, which Professor Armitage hopes for, exist in a world where the United States can go to war without most Americans having any relationship to its suffering? If there has been a long peace since 1945, for whom has peace existed? Well, certainly not for those killed in battles with armed forces, those living under carpet-bombed territory, or those whose farms and villages were napalmed. Nowadays, the precision of contemporary weapons does not produce more peace simply because the blast radius from a drone strike is smaller. The sound of the drone has become part of the ambient environment in some parts of the world, a world now shaped by the watchful eye of surveillance, and in some regimes, an ever-present threat of annihilation. When military ordnance encounters the human body, the categorization of the resulting death as collateral damage matters only to the categorizers. We might, along with Professor Armitage, long for perpetual peace. But in the 21st century world, peace is not a time. It is not a widely shared peacetime. Instead, peace is an identity for those countries and peoples privileged to experience it. For most Americans, peace actually exists as an absence of conceptualization. Leaving warfighting to others, other members of their political community, isolated in particular towns and families, far from the battle, far for most Americans from the battlefield, it simply rarely crosses their mind, unless perhaps a particularly disturbing photograph of dead children appears in their social media feed. They might tweet an outrage and be satisfied to have had their say. There is an absence of, obviously, of the collective suffering that Olmsted encountered on the hospital transport ship, and that Faust argued helped shape the political community in war's aftermath. It is often argued that the production of American apathy about war comes from the getting rid of the draft in the aftermath of the war in Vietnam. That's certainly part of the story, but the true driver of American disinterest in the wars our country engages in, I'm sorry to say, has much deeper roots and is much more difficult to think about how to dislodge. Professor Armitage writes that the American Civil War became a test case for the legitimacy of secessionist war everywhere, which is certainly the case. It would not, however, be the defining model for other conflicts between the American whole and its parts. For example, just one, the effort of Filipinos to achieve independence in the aftermath of the Spanish-American War, when they found themselves instead fighting the American military. A conflict that was not only excluded from the great panoply of American war, but from American memory itself, when their wartime for the Filipinos came to be remembered in American history books as a peacetime, showing again that peace is at its core a failure of memory. I'm sorry I can't leave you more uplifted in a way that I promise you will be from the book. But perhaps the peace that we should seek, if it doesn't exist in time, I believe that it doesn't exist in time, I'm sorry to say. Perhaps the peace that we should try to seek should have a relation to the polity the way the Civil War had. We know that violence and its after effects can draw people together. Wouldn't it be great if people could be drawn together and constitute a political community in relation to peacefulness instead of violence? Thank you.
Thank you very much, Dr. Dudziak. Well, while not, you might say that wasn't uplifting, certainly inspiring. Absolutely. And we appreciate greatly your insights and your very compelling remarks. Thank you for sharing with us. President, do we have time for a few questions? Yes? Okay. So if I might invite those of you who would like to share a question or a comment to please approach the microphones. That I see a couple. I don't know if there are others, but there are certainly two. So please feel free to make your way to a microphone.
As Mary said, we are blinded by the lights, so it would be nice to know that
It's a 70s
still
song. Does anyone remember?
Could I follow up on the Lieber Code? Because you discussed it some, but I didn't quite get to the point of why Lieber thought it should apply in what he acknowledged to be a civil war. And of course, it has so many roots that reach out into the current century and affected the 1907 rules and so on. Could you explore that a little more, and what was behind his sort of seeing something that others had not seen, namely trying to prevent unnecessary cruelty in a civil war?
Mm-hmm. What I try to do in my treatment of Lieber, more extensive than I was able to do in the paper, is to show how tremendously difficult it was for Lieber, first of all, to find the existing sources that he needed to frame the code, and in particular, the frame that was missing for him, that was noticed immediately by Henry Halleck, his boss, also an international lawyer and a Union general, was the framework of civil war itself. So when Lieber sends the first draft of the code to his boss, Halleck says this is fantastic. It's exactly the enumeration of the laws of war and their applicability in our current conflict that we need. But you do know this conflict is a civil war, and you haven't actually provided a definition of that. And Lieber goes into great difficulties trying to find a definition which, as I've shown, I mentioned briefly here, actually doesn't fit the circumstances of the Civil War in 1863, is deeply confused about the difference between a civil war and a rebellion, and therefore blurs, even within the code itself, the lines between domestic police jurisdiction and the application of the laws of war. And I think that ambivalence, not simply about the provisions, the precise provisions on which we usually concentrate in our discussions of the Lieber Code, and indeed its aftermath in the Philippines when it's republished in 1898 and then onward to 1907, as you mentioned, that ambivalence about civil war itself, its boundaries, and how that Lieber's first attempt to provide a legal definition of it is almost emblematic of the near impossibility ever of excluding politics or ideology from the definitions of civil war, especially, but perhaps particularly at moments when that definitional clarity is most demanded because of the importance of the application of those rules of armed combat within a particular form of conflict.
Thank you. I'm going to go get the book.
Mm-hmm.
Wonderful.
One sale, thank you.
Good question. Thank you. I'm planning to get the book also. I'm Lori Damrosch from Columbia University, and because Professor Armitage mentioned internationalized civil wars, and because the discourse about the American Civil War is so important to thinking about intervention in civil wars, I just wanted to ask you to trace from the arguments about intervention and neutrality and the Alabama claims arbitration and all of that, through to the Spanish Civil War and the arguments about intervention and non-intervention in the Spanish Civil War, and then just bring us up to where we are with Syria, because it seems like we rework these arguments from earlier civil wars and we're in total perplexity now. And I think historical perspective on that could be very enlightening to those of us who have to kind of talk law, looking to the historical precedents of the past, including their legal arguments. Thank you very much.
Yeah.
Fantastic. Thank you, Laurie. Well, you've sketched some of the major points from the 19th century onwards. Let me just give a prologue to that, which is my friend Vattel again. The other interesting pivotal move that he makes on the basis of his redefinition of civil war as a war between two nations that have emerged within a state is to go one stage further to say that opens up the possibility for external powers legitimately to intervene on behalf of whichever side they believe to be just. So he is the first major theorist of civil war to link it to precisely that question of intervention, and in particular to do so under the sign of the law of nations or of international law, because of his redefinition of a domestic conflict as an international conflict. Just to give one example, and this is moving closer to the 19th century, is Edmund Burke in the 1790s. So in his later writings on the French Revolution, after the reflections on the French Revolution, uses Vattel's arguments to say, in France in 1789, two nations emerged, a Republican or a Jacobin nation ultimately on the one hand, and one that still maintained its allegiance to the Bourbon monarchy. He said under those conditions and under Vattel's stipulations, the other powers of Europe could justifiably and legitimately decide which of those two nations to support and to intervene on their behalf. It's a very thoroughgoing, at that point in the 1790s, the most radical argument for committed multilateral intervention into an existing conflict which had been laid out up to that point. And you can see in that some of the antecedents of later arguments, not just the ones that you mentioned, but for instance, the multilateral intervention into the Boxer Rising, or in the conflict in Lebanon in 1860, for instance. One can go on with many of these examples. And these are also very generative. For instance, John Stuart Mill writes his famous still for us pivotal theoretical document, the few words on non-intervention, precisely around British policy of intervention into mid-19th century civil wars. So I think civil wars have been very generative of that, those conceptions of intervention, but you're absolutely right that there seems to be an eternal recurrence of playing out the arguments of, if a war is civil, it's somebody else's business, it has to burn itself out, we shouldn't draw in outside powers, to those who take the almost Vatalian or Burkean view, which is this is cracked open in such a way that we should be supporting one side or the other, and that the issue is therefore to decide not the legitimacy of either one side or the other, but upon which side intervention should take place. So we seem not to have advanced tremendously far, in a sense, from the 1750s in that. But I think you're exactly right that going back through the history is one way to show how those arguments have worked their way out, particularly in these internal conflicts. But, and this comes to a point that Mary, I think, would underlay a lot of what Mary was talking about in relation to empire as well. The frame of empire is always around these conceptions, how the apprehension that a civil war is taking place can be used as a mask for imperial or colonial intervention, for instance, in the Middle East, for instance. Also, or Asia has a continuous history, at least since the middle of the 19th century. So putting the frame of empire around that argument about civil war and intervention is utterly crucial from the mid-19th century, I would say, right up to the present as well. So thank you. Thank you very much for that.
And before we go to the last question, Mary, did you want to add to that, or are you okay? Okay, all right, sir.
Thank you, Professor Armitage, for this wonderful talk. You said that you're the first historian to give the Grotius lecture. I may be the only historian in this room. So I'm taking the liberty of asking you a question, and that's to do with Mao and Lenin. I've not read your book, so maybe they're treated at length in your book. But one could argue that though Mao and Lenin have been seen as theorists of revolution, they're also theorists of civil war. I mean, if you look at the parallels between pre-revolutionary China and pre-revolutionary Russia, there's a collapsing state. And unlike in the case of the American Civil War, the established order doesn't command the entire territory of the nation to be. You know, the extraneous influences. In the case of the Russian Revolution, there's the First World War, which has weakened the state. In the case of China, there's colonial enclaves all over. And Mao and Lenin are both using and theorizing civil war as a means to revolution. So I wonder, whether they form part of your history of ideas. But your lecture was terrific, and I look forward to it.
Thank you so much. No, I greatly appreciate that. And the quick and facetious answer to your question is chapter 4, which is precisely about the relationship between revolution and civil war in revolutionary theory from the 18th century onwards. The slightly longer answer for those of you who don't yet have access to the book is to say I agree with absolutely everything you said. And I'm particularly interested in the revolutionary tradition that runs from Marx through Lenin and Stalin, and their blurring of and apprehension of the necessary, almost umbilical relationship between revolution and civil war. I think there's an almost post-Enlightenment prejudice in our political vocabulary that we want to put a cordon sanitaire between forward-looking, future-oriented, transformative revolution on the one hand and atavistic, backward-looking, destructive civil war on the other. But all the great revolutionary theorists, including those you name, were very well aware of what Marx and Engels in the Communist Manifesto called the veiled civil war that's at the heart of revolution. And that's something that I unpick in the book, is the relationship between those two categories and how revolutionary theory itself is really based on the idea of civil war itself being intimately, directly, genetically, umbilically related to revolution, and vice versa as well. So I refer you to the longer discussion, but I absolutely endorse exactly everything that you said. Thank you.
Terrific. And before Lucinda joins me on the stage, I just want to very briefly thank you all again for being here. On behalf of the American University Washington College of Law, our deep thanks to you, Lucinda, to Mark Agrest, Wes Rist, and of course the entire American Society of International Law. Thank you for your enduring partnership with our law school and our programs. And thank you, the board, for putting together such a phenomenal program. Finally, thanks also to our wonderful Professor David Hunter and staff assistant Megan Petrie for putting together tonight's event and working so closely with ACEL to make this a tremendous success. I do hope you will join us at the reception thereafter. Lucinda.
Thank you, Dean Nelson, and to David Hunter and everyone at the Washington College of Law for your support of this Grotius lecture. We've been given a lot to think about. I do expect that you're going to see a surge, both of you, in your book purchases. As a Coloradan, I have to say, Mary, I'm especially pained by your discussion of the Sand Creek Massacre, but Governor Evans is not well remembered for that incident in our state. But it's important for us to think about the forgotten conflicts, and we thank you very much for your discussion. We have a wartime track in this conference. If you look at your program materials on page 75, you will see we have a number of programs on this topic. One that is not there that I want to call to your attention is a late-breaking panel that will take place tomorrow afternoon at 1 p.m. And its topic, fittingly, is the recent missile strikes by the United States against Syria. There are competing events and programs at that time. It's inevitable in a conference like this, but I do want everyone to be aware of it because it has been added just over the last weekend and therefore is not in your printed materials. So with that, we are closed. I do invite you to join us at the Grotius reception, which is in Regency B and C just next door. Thank you very much.